we get the guidelines from the statutes in terms of what cannot be done, through the articles. So if you have any article and you are doing some of this stuff, you must pay attention. The proper one, or the most important one, was the section 723, which was read in class in terms of statutory guidance. And I want all of you to pay attention to that. It applies virtually to anything. And when you go over the piece and substance of that provision, you see that so many issues are covered. Not only, the articles or memo, even the resolutions at the general meeting or by the board of directors, or even your contract. You cannot do it in violation to what the Act provides. And that is why it is very, very important, among other principles that you may learn, that when you are dabbling into altering any of these documents, you must be very familiar with the Act itself. Otherwise, you will not be able to. For instance, outside of the alteration that can be done, we saw Section 314, Section 315, or talking about circumstances in which you can deploy article or memo for purpose of unlimited liability or negotiating limited liability into unlimited one. All these things are possible. Then beside that, I also would want you to look at section 2, let's say, section 54. Just again, that when you are trying to amend your memo or alter your memo or articles, section 54 is also there. Can someone quickly read section 54 for us so that we can move on? And just to emphasize the essence of the need for you to be familiar with these provisions and then take account of them. Yes, anyone to read section 54? Janet, if you want to, yes, Janet's hand, if you want to read, go ahead, please.
Except
Good morning,
to the extent.
Okay, go ahead.
Except to the extent.
Section 54 is lucky. Two people are competing. Okay, maybe one should stop for the other. Thank you anyway for showing so much interest and zeal. That's good. Oh yeah, one person.
Except the extent to which a member of a company agrees in writing at any time to be bound thereby, and anything to the contrary in the memorandum or articles notwithstanding, the member shall not be bound by any alteration made in the memorandum or articles of the company requiring him on or after the date of the alteration to take or subscribe for more shares than he held at the date on which he became a member, or B, increase his liability to contribute to the share capital of the company, or C, pay money by any other means to the company.
Yeah, thank you. At least we've seen it. That is the kind of guidance you need, among others. And again, how rich you are in terms of guidance depends on how really committed you are to karma. If there is no commitment and you are not really dealing with it as a friend, then there is no way you can understand karma the way you should. Because it is the person, or it is the thing you are interested in that you know. If you're interested in a person, you get to know all manner of details about the person. Even as a surprise, you go dig out information just to impress that, I do care about you and stuff. And for those of us who are Christians or who are religious, in terms of getting to know or being in relationship with Christ and all that, and the other one, I can only speak to the Christian one. I'm sure there is some equivalence in the Holy Quran as well. So what is being emphasized is that it is only when you are in good relationship with these people, these institutions, that you really can show commitment to what they say don't do or you should do. It extends to life, not just to law. okay, we are just bringing life into law here because, and in your own interpersonal relationships with your friends, or acquaintances, again, if you want to deepen that relationship, you get to know, you find out information, and it helps. So you move on to your classroom now. If you want to know company law, or you must like karma. So how much of karma do you know? So when we are talking about being a guardian from the statute in authoring memo or article, the question you ask yourself is how much familiarity do you have with this karma? If you don't, then you really can't be guided, But if you do, you will be zealous enough to know more, to want to read more about this, and then be able at least to utilize or deploy them at the right instance. Now, apart from that one, also, let me also refer you to other provisions. Section 2, let's see, section 240. I want someone to also read section 249, subsection 1B. There you also see a particular guidance. That section 249, just for you to know these things are extensive, but then just bringing your attention is okay. 249, let's go ahead quickly.
Any provision contained in a company's article is void if it would have the effect of A, excluding the right to demand a poll at a general meeting on any question other than the election of the chairman of the meeting or the adjournment of the meeting. Paragraph B. Should I continue?
Go ahead, just read B with it.
Okay. Making ineffective a demand for a poll on any such question which is made by any of the persons mentioned in section 248 of this act.
Yeah, thank you. So you can see section 54, actually states what you cannot use your memo article to do, for those who are coming in and what they have reserved, what nature of liability they are ready to take the shares. You can't improve upon their, their liability. They must consent. You must, and that consent also has to be in writing and signed by them. So you can't force things on them. And as regards section 249, it's about voting. It's about decision making of shareholders at the general meeting. When you talk about, a provision of law not to compromise the right to make a poll, polling is in contradistinction to voting by hands. The law says generally that when shareholders are at general meetings and they are taking decisions, is ordinarily by way of show of hands, show your hands. So, and then they count and they announce the result. But there are certain occasions where the shareholder can also say, no, I want this voting to be by poll. That is, let us vote according to the number of shares we have. Because if there are 3 people in a company and their shares, let him say it's 100 shares, one has 60. The other 2, divide the remaining 40 between themselves. And if those 2 that has 40 together were to vote all the time by show of hand, they will always outvote the person that has 60 out of 100. That is the implication of show by hands. However, they may be making decisions that impact their investment. So the person that has 60 out of 100 can say, look, shall we please, so I hereby demand for a poll. Let us vote by our shares. So the 2 of them can collaborate all they want. 60 will always trump 40. So that is to show that you can use that medium at the general meeting to ensure that those who contribute capital more should have a better say in decision making. That is what it simply means. So what 249 therefore is saying is that you cannot alter your articles or insert any provision in it that we make void, that we compromise the right of any of the shareholders to demand for a poll. You must always keep that right sacrosanct. It's inviolate. That is just one other thing you also need to know. And as I said, it's for you to determine how much more you want to know of karma, or how less you want to know. Then I'll give you one more example. Go to section 305, subsection 8. All of this, 305, subsection 8 and all that, you come in the second semester. You can't avoid it. But at least, and even the voting issues, they are all, topics in the second semester, but at least they help us, explicate the point we're making, that there are statutory guidance to alteration of articles. They are scattered. Other hand, the more you read, the more you come across these things. The principle, it is you now finding out how many examples or instances and they are. So 305 subsection 8, please.
No provision, whether contained in the articles, resolutions of a company, or any contract, shall relieve any director from the duty to act in accordance with the section or relieve him from any liability incurred as a result of any breach of the duties conferred upon him under this section.
Yes, so you can see you cannot permit or free directors from liability for violating the duties under section 305. It used to be that was possible. Okay, just for you to understand, the genesis of these things. It used to be possible for companies to insert provisions in the articles for giving directors for breach of duty of care. Yes, it was taken away as far back as the Companies Act of 1929 in UK. And since that time, it was repeated again in the Companies Act of 1948 UK, and which we copied in 1968, Companies Act Nigeria. It was also equivalent provision that is just being read, or that was just read, was also in KAMA 1990. That is section 279, subsection 8. It is now section 305, subsection 8. So it's telling us that you cannot, because directors are the one managing the company. They are in control of his assets. They are in control of his operations. All the key informations, is with them. So, and they have so many responsibilities to run the affairs of the company in such a way as to protect its assets, enhance, the business of the company itself. So why would you free them from a mess they create for the company? But since this article, the shareholders can always do so. Bear in mind that these same directors are sometimes shareholders, and they can instigate others to, to free them from their problems. So, but because there is now a statutory provision forbidding the doing of that through whether by agreement, you can see subsection 8 is very extensive. So therefore, you cannot go by memo, you can't go by articles, you can't go by resolution, you can't go by contract. It's nothing you can go. So again, that is an instance where you have to advise. Your knowledge of karma will help you to know when you are altering, the articles, they are properly guided. And so those are examples. We can't exhaust all of it, but at least the rest is a continuing process. If you are going to continue with karma or with company law in life, often you have opportunity to read more of this provision and then, enhance your capacity regarding these issues we are dealing with. Okay, so so I can put that aside in terms of statutory guidance, and then we started, the case law guidance last Monday at the last class. And in respect of that, I had given sent out cases because it's about case law. So sorry about that. I had a call from my boss, so I had to answer. So as I said, we started that, and then as I said, at this point in time, you must also be able to understand the alteration from guidance that the case law, the judiciary is giving to us. Again, there is the need to, to educate yourself through those cases. Now, but there are some of these cases I will highlight. There is a case, and I want to believe that the class captain have sent those cases to your platform. Everybody has it, and everybody is obligated to read these cases. Class captain, the circulation is done, right?
Yes, sir.
Okay. So if the class captain has circulated it, so I take it that you should start looking at these cases. But I will emphasize some that you need to read. For instance, the Citco Banking Corporation, NV, versus Pusas Limited, and another. That's the one by Privy Council, is fairly recent, by Lord Hoffman. I want you all to read that case. There are some cases you read, you know a lot of cases. Just reading one case, you know a lot of cases. That is one case you really should know or read. All of the other ones are very important, particularly the Peter American delicacy versus Heath is also another case you should read. It is exhaustive in terms of teaching, guiding how these alterations are done. They are very crucial. There are so many cases, but I have picked those ones out so that you don't get overwhelmed. And also in the knowledge that in reading all of them, about 5 or 4, if you read all of those ones, then you're in a good state to learn much more cases and how these principles are applied. Basically, Allen and Goldrich, West Africa again by Lindley is also a case you should read. Anyway, if you read Citco, because it's very recent and it has opportunity to review some of these other cases, you get to know the decisions that were in place, how the later courts particularly the higher courts, are responding to it, whether they are restating the existing principles or refining it. It is very important ordinarily to alter a memorandum or articles. You need a special resolution to alter an article. And of course, if you are going to, pass a special resolution, that resolution must be made, for the interest of the company as a whole. When you get to read these cases, you also see the kind of situations that make people want to alter the articles. Articles are regulations. So there are certain exigencies that will lead companies to change or alter their articles, because they want to either accommodate a particular interest or to or promote a particular wing of the company, or sometimes it is basically for the interest of the company. So when these things happen, if you have the vote to carry the special resolution, it is done. But many a time, such kind of vote is challenged because some people think that it is prejudicial, that it is unfair, and stuff like that. So it allows the court to examine the reason why it is to be done. If you see, if you read Sitco, you will see, and I don't want to guide you. I want you to, or at least to understand, guide yourself. Why was there a contest of the resolution of the alteration of articles in Sitco? There was a reason why they contested it. As you could see, they did it to the Privy Council. So which means the trial judge, the trial court, the Court of Appeal, they were not satisfied. They had to go to Privy Council because that country is still beholden to UK, where they provide, because the Privy Council composes of members of the UK Supreme Court, like the House of Lords. They are the ones that will deliver the decision, but not for UK, but for the country that is associating with UK, to provide an equivalent of House of Lords for them. So we used to have Privy Council, but so sorry. They are tampering with my time from the school. So there are not people I can disregard. So we'll go. So as I said, as I was just trying to speak to Sitco, at least to energize you to want to read about that case, which I believe is very important. Now, so when you take a company there are so many interests. There are some interests that relates to only the shareholders. Only the shareholders. Like, for instance, you want to declare dividends and you are classifying those who will qualify for preferred dividend and stuff like that, which means some people will be denied. That is a particular activity that could go on within the company. Now, and someone says, well, we are voting in favor of it because we believe in good faith. It is in the interest of the company. But then the question is that as a whole, when you are dealing with the company is it the company as an entity, as a separate entity, or the company comprising all the shareholders? The point that some of these courts do make is that there are cases where what is being sought, the amendment being sought affects the interests of shareholders amongst themselves, not necessarily even the company. So what would be the standard formula to say that, okay, we are voting in favor of alteration because we consider in good faith to be in the interest of the company? If you read American delicacy and again another case of Mill versus Mill, these are all Australian cases, those two. Peter American delicacy is Australian, and Mill versus Mill is also Australian. But of course, Citco is from British Virgin Island, but it's still affiliated with UK. So these are cases, and as I said, read Lord Hoffman, the exhaustive judgment, elucidating one that puts you in a position to know about other cases and how they are. And when you also look at short words and cost brother, again, it is the circumstances. Look at the circumstances that led to alterations being made. So, and to determine whether that is justifiable or it is not really justifiable. Towards the end of Citco judgment, and Citco is something, it's a case that every one of us can actually tap on and read, because as it is online, you have to go to library, and so you can call it after your class, online, and then you start reading it, at least to give you a heads up in this whole issue of application of principles. So the question is, how are the principles that are formulated by court, particularly in Ireland's, is important, in Ireland's case, it's important for you to know. And in knowing them, also to move further by reading a case like Citco and other like cases that actually provides a much better analysis, of the principle, and of course the application of those principles is very, very important. That is why if you don't read this case, there is no amount. I can't be dictating facts or cases to you or somebody head. You are lawyers, as far as I'm concerned, being in year 5 or semester, you are gone. To the legal realm. So you should then dignify your status by backing it up. And you can only back that one up by reading cases now and taking them more seriously. When you read cases in year 2, you are a different person. Now you're reading cases in year 5. You have better understanding of law, lingo, and all of those things. So please, and of course, I also gave you the Gamboto's case. That is also Australia. Now, there's a revolution. Now, when you read Citco towards the end, you begin to see Lord Hoffman disagreeing with the fact that, well, the principle in Gamboto really is not English law. And when you read Gamboto also, you also begin to see judgments referring to the fact that some of the decisions in England is not, they will not approve it for themselves. And all of these two cases, they are common law countries. And for us, we don't have too many cases where there is proper elucidation of principles and application in Nigeria, and so you have, and we can be led by any of these decisions, because we are in Nigeria, their opinions are merely persuasive. They are not binding on our courts, particularly on our Supreme Courts, who can formulate our own principle. But many of our courts too, or in most cases, they also refer to these cases from time to time in articulation or in setting standards. So when you have this kind of divergence, then the question is, okay, where should we go? Which principle is better? Which one do you think we may recommend, for our course to follow? Or which of them present us a better understanding of the issues involved? There have been cases, that clearly says the principle of you vote, your shares in good faith to pass a special resolution if it is in the interest, of the company as a whole. Many cases have said that there is nothing like company as a whole because it depends on the subject matter. If the subject matter is relating to the company, the success of the company, to save the company, to project the company forward, yes, that is understandable. But if it does not touch it, if it's about the members, then it has nothing to do with company. So therefore, that has to be taken into account. And there are, there are dicta in the High Court of Australia in Peter American delicacy, and much more so decisions of the High Court of Australia also, which is their Supreme Court there, in Gamboto's case, that clearly disagree with some of these English courts. The good thing about Gamboto is that there were some English cases that they accepted was good law. And there was also an attempt to formulate, the law that will apply. As I said, cases have been divided into alteration of articles, that affects generally, the contents, the interests of the company. But there are some alteration that try to expropriate the property rights of shareholders. Like it affects the rights of a shareholder, and that is expropriation cases. So what are those kind of principles that would apply? So those are the issues you watch out for when you are dealing with Gamboto, because Gamboto was one case that sought to take away shares from people. Citco was one that really empowered the chairman of a company in such a way that others really, some objected. But the truth of the matter is that there was an overwhelming support for that alteration, notwithstanding those minorities that were affected still went to court to challenge it. So this is the fact that will give you the context that makes you understand the judgments that ultimately is given. That is why I am promoting that you take more seriously. You should take more seriously this reading of cases, so that you are comfortable with having to deal with these issues. I'm more comfortable to deal with these issues. So, and as I told you, Lord Holtzman in Sitco's case is very, very important for us to understand, and of course to read the other like cases. Now, so that's about what you have to do, on this part for this semester. From my end, I'm sure Professor Lawoyin Akaya will come around to continue with you till the end of the semester, and then discuss possibility of CA, just for the continuous assessment and stuff like that. So that is how far. I don't now know if you have questions to ask me, from what we have been doing, the areas we have been touching on, and all that. So is there anybody who has read Allen's case or read? I think I sent it since yesterday. I don't know. Is there any one of you? I know some of you are always very, very hardworking ahead. So Yes, you can raise up your hand if you have questions to ask. How many of us? Hello. 270. Yes, okay. Mariam also. Go ahead.
All right, good morning, sir.
Mm.
Yes, sir. So I have a question in respect of the bona fide interest test for determining the validity of proposed alterations of article. So, sir, when I was reading it, I learned that there are two limbs to
One,
this
sorry. Which one
Yes, sir.
did you read? Which one?
Oh, I read
The one you...
all the cases, but to be more precise, I saw the limb thing under Shuttleworth, case.
Yeah. Did
Right,
you
sir.
read
And
them?
one of the, sir?
Okay, go ahead. No, just go ahead. Go ahead.
Right. All right, so my question is tied to this subject. I learned that the bona fide test has two limbs: the objective test, using the reasonable man's perspective to the alteration, whether it is oppressive and extravagant, and the objective test, which was eventually applied in a case that I read, Green Heart against Harding Cinemas. But I couldn't really understand how the objective test was applied to decide whether or not a proposed alteration of the articles of a company is, should I say, is done in good faith, that is bona fide, or it benefits the whole company. I don't see how, in fact, a subjective test can work hand in hand with the objective test of the reasonable man's test to decide this, to apply this principle.
No. You see, there is nothing like, if you read the foundation or the laying down of those principles, it is those people voting in good faith in what they believe to be in the interest of the company, in what they believe to be in the interest of the company. Of course, so that eliminates objectivity, because it has to be what they believe in good faith to be in the interest. You see, circumstances is very important. That is why it is very important. It is because even the court says that it is not what the court believes, but what those people voting believes to be in the interest of the company. Okay, so there is nothing objective in voting to alter shares, because is it possible you are altering shares, you are altering articles with respect to what will benefit you as a class of shareholder. There's nothing objective there. That is why you read Peter the Legacy, Dixon J in particular, very fine judgment. They open it up that there is nothing like, like it's a pretense that you are voting in the interest of, when indeed what is happening is not about company, but about the person, the shareholders themselves. Let me listen to Uzo. Uzo, yes.
Good morning, sir. My
Yeah.
question is as regards the issue of political parties. Issue of companies cannot donate money to political parties according to Section 43(2) of the CAMA. So you referred us to read the Constitution, that's Section 221 of the Constitution, as regards no political party other than an association can canvass for votes, etc. But my question actually is, the word the Constitution used, the word that was used was no association. And then when I try to look for the definition of association to see if it encompasses companies, I found out that the first alteration has removed Section 229 of the Constitution that defines an association to be a body corporate or some other things. So my question, sir, is that
Sorry, before you go
association...
forward, did you read the Electoral Act?
Yes, sir.
So does that one permit entities or corporate or companies to donate?
Yes, it permits entities below a particular amount, sir.
Okay. Is that not in conflict with Section 43?
Exactly. It's also in conflict. Yes, it's in conflict because...
Is there a resolution clause in that, in the later one, the 2021 Electoral Act? Did you find out?
A resolution clause?
Yeah, that is, if, okay, Electoral Act is empowering companies to donate.
Yes, sir.
CAMA says you cannot donate.
Yes, sir.
Okay, so and that is a conflict. It was resolved in favor of one act or the other against the other act. So those are students, those are the areas you have to watch out. The supremacy clause, that is, if there is anything in conflict with that provision elsewhere, which wants supervision or stuff like that. So that's how, because you have two legislation, I think they have removed the issue of the entity, in that definition in the Constitution. That was a bigger problem before, because for a long before that amendment was done, companies are not allowed, to make even donation as such in certain circumstances. So, but I think they got it, and they didn't reconcile the CAMA Electoral Act and the Constitution, particularly because of the supremacy power of the Constitution. But I guess they've at least helped themselves. So the two remaining provision in conflict is the Electoral Act and the CAMA. And I'm not so sure. So check the Electoral Act and see if there is, any attempt to protect the supremacy of the act over CAMA. Okay?
All right,
So,
sir.
Taiwo Amao, have you spoken?
Good morning, sir. So
Okay, yeah.
My question is concerning section 27's 1C and section 44 of CAMA. When you were explaining this, you mentioned something about, section 44 says that a company shall not carry on business expressly prohibited. And then while looking at section 27C, we were talking about the fact that 27C just says that the company should state the object in its memorandum. But then 44 was saying things that are expressly prohibited, and we're like, that stating is different from expressly prohibited, and that there's kind of like a conflict. But then why really I was trying to look at it, that if we look at 27 section 27(1)(d), it says restriction. If so, for 44 saying expressly prohibited, doesn't restriction apply in the sense that you state the things that
you see the restriction? Just be careful. If you look at 27(d), what is it talking about? Restriction, if any, on the powers of the company is to restrict the powers of the company, not the capacity. You understand? Powers are different from capacity. Remember that section 43 empowers the company, in a way that is unique. We discussed it before. So if section 23 gives that kind of extensive powers, what that provision says is that although this power is big, but you can place any restrictions on your power. Again, once you take away the part of what you can do in a specific way, so you can see the background to section 27(1)(d) is section 43 that has given plenary powers to the company. So, but then to qualify that, it then empowers the company to restrict that wide power, so that once you restrict it in your memo, going over against what your restriction has done with your ultra vires. Okay, so that is how you link it. But don't conflate that with capacity. The capacity is the power to be able to enter into transactions. So many countries have said any company can do that a company can do any lawful business, which means it is also as big as it can get. However, if there is a particular business you don't want to do, you can prohibit yourself from doing so. Now, so what you are trying to say, what we discussed in class is that if we retain section 21C, 27(1)(c), in terms of statement of what businesses you can do or objects you can pursue, and you concede to that, then you have a limited capacity in contradistinction to being able to do anything that is lawful. capacity is limited. Okay. Now, section 44. I don't know if you had section, if you had 1990 CAM. I refer section 27(1)(c), in CAMA 1990 to you is the same as the one in 2020 now. And I also link it with section 39 of that act. If you check the two, that is how those compare. Without saying that you cannot pair, it doesn't seem to be that section 44 was made for section 27, because it does not make any sense. However, it appears section 44 appears more attuned to section 35 of section 1. Okay, so yet what is the other provision in the like of section 44 should be servicing section 27(1)(c). So those are the things that I brought out for you to think more about and reflect on, because of the situation that we have in our own legislation, CAMA 2020. Okay?
So please, just one short follow-up question, sir.
Go ahead, quickly.
Okay, so still on that 44. So you're saying that when the sentence is a company shall not carry on any business expressly prohibited, the on any business there is referring to the nature of the business in section 27(1)(c) and not the powers. If it's powers, then we're going to section 43.
Yes, you see, when you are reading section 44, section 44 is about, is a reference to the capacity, general capacity. It has to be in reference to it. If you read section 44 and section 35, you will be at peace in understanding what they're saying. But I'm saying that because section 44 is an innovation to is a change of what was there before. The template that should have been for 44 is 27(1)(c). But because they introduced section 35 subsection 1 as the template, that is to show you that section 44 aligns more with section 20 with section 35(1) than it would for section 27(1)(c). We are maintaining, and that is the confusion that is created because we are running two systems simultaneously within the same legislation, which is wrong. It's not done. Okay.
All right, thank you, sir.
Hello, Folakemi.
Okay, sir. Good afternoon. So my question is on the cases that you said we should read. So when I was reading, I found out that Sidebottom and Kershaw and Lees established the bona fide interest test. So I wanted to know, like, how exactly do the courts determine what is the bona fide interest of, especially when they're like majority and minority shareholders? And from what I was seeing, the court seems to like side with the majority shareholders, except for like what happened in Gamboto case. So how do the courts actually know like what is the bona fide interest of the company? Because you can't satisfy everybody at the end of the day.
Yeah. Yes, that is the problem. That's why if you read Gamboto excised some of these good to read, difficult to understand or apply from the statement of principles. And it is very important that if you are read, if you read these things, I'm not sure you have read them once. Is that correct?
Yes, sir.
You just don't rush them. You have to read them twice, particularly Gamboto. Read Gamboto, and when you are reading these cases, pay attention to the circumstances that led to the alteration, and the resolution. It is what informed the alteration that an inference of good faith for the interest of the company, can be garnered. If you do not pay attention, you cannot, it is difficult. That is why in Australia, they are much more practical to reality than just deceiving. That look, it is not every this formula of that we are passing a resolution in good faith for the interest of the company. It is not every of these things that you are doing that affects the company. What about those who that affect the shareholder, where everybody has a right, and as a shareholder, you can vote for your own interest. If a thing affects you as a shareholder, you have a right to vote. You are at liberty to vote for your own interest as opposed to voting for some some artificiality that is called a company. That is not you. Okay. And why should you vote for a proposal to alter that is going to prejudice your interest as opposed to support it? So it is, but by and large, if you look at the circumstances, like for instance, there was a particular case, relating to a director that has cheated or that has, been found to engage in impropriety and stuff like that. And they were ordered to be removed, and there was a vote to remove him and stuff like that. And there are cases also, like in Ireland and Gold Reefs of West Africa, there was an amendment, a proposed amendment to extend a lien on fully paid shares by, a member who is dead and who is owing the company. And they extended a lien to it, and it was challenged. So again, look at that circumstance and then see whether it was fair. Because are they trying to protect the company? If this circumstance is justified so, and there is a vote in favor, the court will not dabble into it and replace their discretion and decision with that of the court. Okay? Ajayi.
Sir.
Ajayi Oluwatomide.
Yes, sir. Good afternoon, sir.
Good afternoon.
Yes, sir. Please, my
Go
question
ahead.
is in relation to
Okay,
section.
but move close to your system. You are distant.
Good afternoon, sir. Can you hear me now?
Better, much better.
Okay, so my question is in relation to section 53 and section 51 of CAMA. So I don't really understand where you said section 53 is contrary to section 51. So I was hoping if you could explain it.
51. So is it 51? What is the title? What is the title of 51? I want you to say it.
Mode of alteration of business or objects.
Mode of operation. Okay, just read subsection 1.
Okay.
Have you read the provision of section 51 itself? It's long ago, and I'm not sure that you have read everything, but have you even read it halfway?
Okay, I only read section 51 sub 1.
You just did that. Not even the proviso that goes with subsection 1. So okay, here's what you do. I will try and attend to your question, and also we plead with you to try and read this particular section. If you don't, you can't get it because they are addressing the same thing. Now, section 53
Mommy has
talks. Hello. Are you still there?
Yes, sir. Yes, I can hear you, sir.
Okay. Now, section 53, 51 talks about alteration, mode of alteration of business or object. Business and objects, where do you find them?
Okay, business is for companies limited
I know
by
where are they to be stated?
in the memorandum.
So, which means when you are dealing with 51, you are actually dealing with alteration of what?
Memorandum.
Good. if you go back to section 53, what's the short title of that, or the marginal note?
Alteration of articles.
Good. It's supposed to be, it is alteration of article, but it then veers. It then veers by saying that that apart from empowering company to alter his article, it then veers and says that it's also alter or add to his article, including the deletion or modification of the provision stated in section 27(1)(a) to D. So ordinarily, this is heresy, because you cannot, what section 53 is saying is that you can use the article to alter the memo. Now look at the proviso, and then the alteration of articles is done only by the members in their own meeting. However, if you look at section 51, the proviso says that provided that if to start a set where a business has stated its business, a company has stated its business object in its memo, such a company may, at the meeting of which notice in writing has been duly given to all members by special resolution, alter the provision of its memo with respect to the business or object of the company, provided that if an application is made to the court in accordance with this section for the alteration to be cancelled, it shall not have effect except insofar as it is confirmed by the court. Now, more so, there are other steps that you need to take, like informing that application under this section may be made to the court by the holders of no less than, then you talk about the value, the debentures, and all of those. So it is a much more rigorous provision than for members to just, use the articles to delete all of those things. That is the seriousness of that kind of provision that I want to bring out. I hope, are you following it now?
Yes, sir. Yes, sir. Thank you very much, sir.
So you will see, if you are able to read that section, you will see, even you yourself with questions. So if it is this extensive, the court is involved, the debentures holders are involved, and you have to find all of these things with the commission. So in fact, there is even a need for confirmation to a court. So you ask yourself, so how can this whimsically be done, through the articles? Articles cannot alter a memorandum. It is not, how that is done. You can say that alteration as you can find it in section 51 and other sections. So let's take another one. Yemi Adedeji. Yemi.
Good afternoon, sir.
Good afternoon.
I can recall you saying that section 53 contradicts section 51. What I can recall you said was that section 53 contradicts section 50 of CAMA, because on section 50, it was stated that cannot alter the company's, you cannot alter the name of a company without recourse to the commission. And when we got to section 53 is now saying that you can alter that name by deletion, by modification, and all the other elements of section 27 sub 1A to D. So what I can recall you said was that section 53 contradicts section 50, not that section 53 contradicts section 51.
There are so many areas that section, you see, all of those things in section 27, right? There are special ways in dealing with them. And there are provisions of the memo. We generally had read a provision, if you recall, maybe was it section 49 now? Obviously, when you look at section 50, section 50 actually provides for how to alter the name of the company that will state in the memo. That is also alteration of memo. There's a special provision for it, and not the one that Section 53 is telling us to do. And when you look at Section 49, for instance, it says a company may not alter the conditions contained in its memo, except in the cases and in the manner and to the extent of which extra provision in this act is made in the act. That is also a provision taken from Section 44 of 1990 CAMA, ipsissima verba, the same provision. So that is in Section 49, telling you that you can only alter in those circumstances. And then subsection 2 tells you what constitute conditions contained in memo of 49 subsection 2. It will take time and reading for you to put all of these things together. And that's why I can see some difficulty in reconciling these provisions. You are perhaps just reading this for the first time. We have been reading it for quite some time now, so we can see a little bit far than what we are, but it's a process. So if you look at that one, so 50 by 53 by implication will contradict 50. 53 by implication will contradict section 51. Definitely the 50 relates to the name in terms of alteration. That is how it goes on and on like that. Okay. So who else is raising up? I hope you follow it, the last speaker. That is Adedeji Abiyemi. So I was talking to Adedeji. Apparently, I hope I have not lost him. Uzo, is Uzo still, or is this?
Yes, sir.
Okay, did you raise up your hand, or?
Yes, I did, sir.
Okay.
Yes, sir. I have two questions, sir. As regards section 53 and the other provisions of the CAMA that it contradicts with, I was thinking that the first phrase of section 53 already provides that subject to the provisions of this act. And as you rightly interpreted it, that when you're trying to alter any article, you have to pay attention to statutory guidance. So the last phrase of section 50 that provides that, including the deletion or modification of section 27(1)(a) to D, if we are interpreting it subject to the provisions of this act, it will mean that if there are already provisions of the act that contradict section 27, that contradict the last phrase of 53, it will mean that that last phrase of section 53 is void to the extent of its inconsistency. So I was just thinking that, is that a way to say, like, section 53, even though it looks contradicting, the contradicting effect has been watered down by the first phrase of 53 that says that subject to the provisions of this act? It will mean that all the statements in section 53 is relying on as long as there is no contrary provisions of this act in CAMA. So since there's already a contrary provision in section 50 that provides for how to alter the conditions in section 27, and even 51 that provides for objects, can we say that, or can I say that that last phrase has been watered down? That's my question, sir. My first question.
You see what it does when you look at the gamut of conflict, reconciliation that is bound to occur. You don't set a law. A new law is supposed to bring peace, not to generate a tsunami. There's a tsunami as far as I'm concerned, and it's simply because there was no proper housekeeping. That's what we call taking stock housekeeping to ensure reconciliation. All of these sections shouldn't be fighting each other. There is something somewhere that went amiss. There is an overlooking of some of these things, which we are looking at and digging deep in, that were not taken into consideration as if they matter. But it is out of their hands. It's no longer with the legislature. It's with academics and practitioners and even the courts. Some of these things that they are not easy. Where if application of law generates a lot of cost, then that law is not efficient from the economic standpoint. Why should you state a law that has to be contested in court before we know which one is which. Yes, your argument I note, but you may have to get to court to confirm your own view, from the view of the other person you are fighting on the same issue. So, and that introduces cost. Sometimes it has to be delayed until the last word is heard. You don't even know where it is. That means that law is not efficient. If a law generates so much litigation to get what was, if you look at section 1990 CAMA, all of these provisions that have been listed there, they were replicating CAMA 1990, the relevant provisions. That, they are replicating it. And in doing so, they introduced some strange fires into it because they felt this is cool. Those who felt it was cool, clearly they didn't understand the far-reaching provisions, that they have to take into account in introducing those kind of legislation or those provisions from other countries. So and in doing so, they created problem for everybody. But that is what it is we do in academics, at least, to look at what they didn't see, the lawmakers, in the hope that when we talk about these things to them, at least they can see it fully. There was one nasty mistake they also made in section 240 subsection 2. They introduced the use of internet in the ICT in the holding of companies, but they only limited it to private companies. Private companies are like you and your family having meetings who have formed like Solomon and Solomon. Everybody can really stay in the house and have a general meeting. You don't need a private company doesn't really need the ICT to hold general meetings. The company that needed it or that will need it is public companies where the shareholders are dispersed all around the world. That the one that we like or that we use, that would want to deploy ICT to attend meetings. But they took it out of it. That is only for private company. And that was a mess. I guess at some point when we made the cry, they got the message that this was a mistake. And then this Business Facilitation Act, they quickly corrected it. So these are mistakes that might not have been open or known to those who are behind these things, but which in time they will get to know and understand. Okay. So who else has questions?
Sir, my second question, sir.
Okay, go ahead.
Yes, sir. Yes, sir. So my second question is, I know that we've talked about the distinction between object and business, and we've laid it to read that business relates to companies limited by shares, and yes, and then object relates to companies limited by guarantee. But why are we interpreting section 35 that provides for only objects to include objects and businesses? Why are we not interpreting section 35(1) to just, okay, maybe that they are stipulating for companies limited by guarantee? Since 35(1) only uses objects, why is object 35(1) encompassing business companies?
Business.
Yeah, business, exactly, businesses and objects.
Okay.
That's the question.
Okay. You see, again, you need to know history about these things. What did I tell you? Where did I tell you we got section 35(1)?
From the UK Act, section 31 of the UK Act.
Okay. That section 31 refers to object. So they just copy it. Meanwhile, so if you saw object, I am sure that they were making references to section 27(1)(c), which includes objects and business. So it is part of the housekeeping that wasn't done. Nigeria, for the first time, we have the phraseology of section 27(1)(c) over the years has always been object clause. That is it. It was only in 1990 that we distinguished object from business. And in doing so, there is a report of the Nigerian Law Reform Commission in 1988, preparatory to transiting to CAMA 1990, that suggested that businesses should only be for those companies who are for profit, whereas object is more adaptable to those who pursue, companies limited by guarantee who have a particular need to really foster and promote. So that is how we got into object and business under 27. But the two of them, whichever one, if you are a company limited by guarantee, you will state your object, not business, because you are not associated with profit making for yourself or for the members. You can only plow back your profit into your business. So that is justice. So it is part of the same mistake that when you are copying, when you are getting involved in legal transplantation, you must know what you are transplanting from another country into your own country. Otherwise, you end up, if you do not export or import the same with the context that makes it a good law there, it will end up being a bad law where you are bringing it. And as it is, you can see Section 35 subsection 1 appears to be a strange fire in Kama because it wasn't done properly. It left a lot of things and there's no tidy, it wasn't tidy. There's no proper housekeeping, reconciliation, alignment of existing provisions. Just as you are bringing provisions from England, you are also retaining the same set of provisions in the previous law of 1990 comes. So that is where this problem, but it's not a problem, it's for you, it's for us to point these things to you guys so that you understand, some of these issues and you can really stand your ground to discuss them, academically, okay? And of course, it may get to the mainstream of advocacy where courts will be confronted to deal with it. So all of these things that we are talking, they will have to confront it and reconcile it or make some pronouncement on on that. So maybe at that point in time, everybody will know that indeed some problems here that the lawmakers must step into tidy up. Okay. Yes, that. So any other now I just want to make an observation. One, I want to thank those who continue to provide life to our engagement here online. Online is not a particularly good way. It has its own value and advantages. It allows us to relax and then students to relax and participate and stuff like this without having to run back and forth. So we are bringing the law to you or lectures to you at your place of abode. But the disadvantage of it is that it's also a platform through which a lot of us can get very passive, and over the period I've been with you this semester, only very few people, have been speaking and making contributions. They should be for themselves, but they are the one that gives life to the discussion we do here, and I can name all of them. I'm so used to their names that I can count them in my hands. So suppose they are not part of this class. So you ask yourself, are you all going to be looking at me? I will be tired of hands, but I keep looking for more hands. And it's because, even searching your name, the whole lecture will finish. The lecture period will finish. So you like it because, but I shouldn't chase. It is your class. It is not mine. Just as the people that are struggling to speak, to contribute, that's how everybody should be doing. Because your class, you never know what it is. Those who spoke and corrected, those who spoke and are validated, they leave this place different, more energized, more reinforced, more confident about these things because they're able to speak and heaven didn't fall around them. But for those who never did spoke, it's like the jury is out. You will never be sure whether you should have said one thing or the other. So it's not particularly good for you to keep keeping quiet. Try as much as possible to prepare for class and read. It's your class, not mine. I'm just leading the class to expose you to things you might have to be able to think about, which you have not thought about because of where you are. You are growing in knowledge, so we're helping to develop that knowledge, that capacity. That's all this is about. It's not just to come in here and sit down, no single contribution. I hope it will be better the other time. But at any rate, I thank all of you for the attendance has been good from what I see. Participation has been very abysmal, also from my experience. But for those who made a difference, I really want to thank you for being, very diligent and at least taking the risk and damning the consequences. You can never be afraid of not getting it right. Nobody gets everything right. Okay. So on that note, I want to wish you luck. Have a very wonderful day. Thank you, everyone. Bye.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Yeah, thank you, sir.
Thank you, sir.
Thank you, sir.